rise. Before the jury joins us, I want to make a brief record. Corrected 1017 has been provided to counsel. Any objection to the corrections made, Mr. Steffen? Mr. Nelson? They have all been included in the jurors' packet. In addition, I intend to tell the jurors when they come back that counsel noted that one of the requested instructions, great bodily harm, was not included in the packet. It has now been included. I will read it to the jury. They all have it at the end of their instruction packets. Any objection to that, Mr. Steffen? Mr. Nelson?
No, Your Honor.
All right. Anything else we should take up?
Judge, we've agreed by stipulation that I'm going to mark. I've showed Mr. Nelson 3 photographs. We're going to replace the actual physical exhibits with photographs. Exhibit number 7, which is the Peter Charlie's black shirt. Exhibit number 8, which is Peter Charlie's white shirt. And exhibit 37, which is the knife. We're going to replace with these 3 photographs. No objection, and so stipulated, Your Honor.
Thank you. The other thing I want to notify individuals in the courtroom of is that when this case goes to the jury, the Justice Center will be closed. It will be closed during deliberations. When we have a verdict, I will notify counsel and law enforcement, who will then contact others. 1 hour after those initial calls are made by the court, the verdict will be read. So I'll restate that. The Justice Center will be closed during deliberations. Once we have a verdict, I'll notify counsel and law enforcement, who will then contact others. 1 hour after those initial calls are made, the verdict will be read.
Your Honor?
Yes.
My apologies. Can we turn this media off and lift the screen?
Please be seated. Ladies and gentlemen, when we took what I thought would be a quick break between closings, counsel brought it to my attention that I had neglected to include one of the instructions that had been agreed upon. And since we were going to have to get that photocopied and added to your packets, we decided to break for lunch because your lunch had come in the interim. So if you pick up your packets, I've added the very last instruction. Which is great bodily harm. Great bodily harm means injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or similar injury. My apologies for not including it. Mr. Nelson.
Thank you, Your Honor. Please, the court. Counsel,
Mr. Acre-Kendall, ladies and gentlemen of the jury. Before I begin my closing statement, I just want to again take this opportunity to thank you each for the sacrifices that you've made over the past 6 days. It's a busy time of year. It's a busy time of year for all of us. And we recognize that the imposition that this puts in your lives and the inconvenience that it is for each of you. Now, Mr. Stephan and I have done our best to expedite this process and get it to you for your consideration as quickly as is possible. And I, again, thank you on behalf of Mr. Acre-Kendall for your attention and your patience and your willingness to serve. The evidence in this trial has established the following fact. Peter Kelly was respected by his community. Peter Kelly was liked by his friends. Peter Kelly was loved by his family. Peter Kelly loved his wife, and she loved him. Peter Kelly loved his children, and they loved him. There is not a person in this room that would disagree that the death of Peter Kelly was tragic. Peter Kelly will be missed by his family, and they are entitled to their grief, and they are entitled to be angry. But the Kelly family's grief must not be permitted to overshadow the rule of law. At the beginning of this case, during the jury selection process, Judge Gail Wyrick eloquently expressed to you what makes this nation great. She told you that what separates us from countries like Afghanistan or Syria is the rule of law. That while we have our imperfections, it is the greatest system of justice ever conceived by the human brain. The first day of this trial, we remembered the sacrifices from December 7th, 1941. And we honored those soldiers for their sacrifices to preserve our freedom. But they don't just preserve our freedom. They protect and defend the rule of law. And we're going to talk extensively about the law and what it means and what self-defense means. And the words of the law have meaning. There are two important principles that have to lead your deliberations. They have to, from the very beginning, be the first considerations that you make. The presumption of innocence and proof beyond a reasonable doubt. And I'm going to take just a few minutes to talk about what those mean. You've been repeatedly reminded that the presumption of innocence applies in this case. But our human reaction, our natural human reaction, is to not apply the presumption of innocence. It's to apply the presumption of guilt. Think of any time you read a newspaper and you pick up a newspaper and there's a story about some heinous or horrible thing that's happened, and there's the picture of the person who's accused. Your brain says, must have did it. That's the presumption of guilt. But our system, our Constitution says you've got to set aside that natural reaction. And you have to presume Mr. Acre-Kendall not guilty. That is the starting point. The very best analogy that I have ever heard about how you understand the presumption of innocence is this. A lawyer brings her nephew to court one day. And it's an arraignment court, and they're bringing in the defendants from the jail, and they're arraigning them on the charges. And with each and every defendant, the nephew leans to his aunt and says, what did he do? What did he do? What did she do? The lawyer says, well, he's accused of this or he's accused of that. But then a surprise defendant walks in, and it's that young boy's mother. And his reaction is not, what did she do? It's, what are they doing to her? That's the presumption of innocence. What are they doing to her? Likewise, proof beyond a reasonable doubt. Again, the judge has instructed you and given you the words that define what a reasonable doubt is. And we have lots of standards in our justice system. And we use the scales of justice to illustrate what that means. One standard is the preponderance of the evidence. You just ever so slightly tip the scales in your one side's advantage. Another is the preponderance of the evidence, where that scale gets a little bit higher. But this is the highest standard that the law recognizes, beyond a reasonable doubt. The doubt that you would have in your most important affairs. And again, lawyers try to explain this to people. How can we think about the proof beyond a reasonable doubt standard? And we say, well, it's your most important affairs. It's like buying a house. It's like getting married. Those are pretty big and important decisions that you make in your life. But here's the thing. You can sell a house. You can divorce your spouse. The difference in this case is that the decision is final. It is a final decision, and it is not to be taken lightly. So it's more akin to the decision to remove someone from life support, because that is a final decision. And if you have any inkling, any reasonable belief that that person could survive, you don't. Ultimately, your duty as jurors in this case is to decide the facts of the case. You are charged with the incredibly difficult task of culling through the testimony of each of these witnesses, assigning weight to be given to their testimony, and determining whether their testimony was credible in light of all of the other evidence and testimony. And ultimately, you will be asked to apply the law as it has been described to you. The rule of law must be at the forefront of your deliberations. And as you examine the nearly 100 pieces of evidence, the testimony of 17 witnesses over the past 5 days during your deliberations, I submit that you do so in the following way. 5 steps. First, consider what evidence is not disputed or just simply consistent with all of the other evidence. I'm going to go through each of these. Second, do not be misled or distracted by minor inconsistencies. Third, do your best to reconcile the major inconsistencies in the case. Fourth, apply the age-old saying that actions speak louder than words. And fifth, follow the law. Words have meaning in the law. So first, the first step I propose is that you consider the evidence that is undisputed or just simply consistent. So what are those facts? And again, I'm not going to rehash every single detail. And I agree with Mr. Stephan that that would just take us another 5 days. But there are facts that are just not disputed. For example, we know that everybody that day decided to go fishing. It was a beautiful spring day. We know that there was a verbal confrontation across the river. We know that Peter Kelly and Ross Leckman made a conscious decision to drive across the border and into that park. We know that Mr. Kelly and Mr. Leckman had been drinking. We know that Mr. Acre-Kendall and his friends were using marijuana. We know it was dark. We know that Mr. Acre-Kendall's party was surprised. Everybody agrees, including Mr. Leckman, that they did not expect them to show up. We know that there was a physical confrontation almost immediately. Everybody there that night knew that Mr. Acre-Kendall had pulled a knife. Everybody agrees on the general path that Mr. Acre-Kendall took as he walked along the side of the car. Everybody agrees that Mr. Kelly was right there along with him. We know that Mr. Kelly was stabbed. We know that he was only stabbed once. We know that Mr. Kelly ran off. And we know that Mr. Acre-Kendall left the park. There's no dispute. All of the witnesses have essentially agreed to those basic facts. And there is other evidence that is just simply consistent with the evidence. Think about the blood evidence in the car. We know, again, that Mr. Kelly's blood was in the car, as was Mr. Acre-Kendall's. And you've heard the testimony of Mr. Stalkey, who explained that it was this impact, it was not the impact splatter, it was this cast-off splatter in there. And he was saying it could have been from the knife shaking or being waved around. But when you, again, see how is that consistent with the other evidence, all four of those people testify, or the three that were in Mr. Michaels' car, all agreed that they were freaking out in there. They were looking back. They were looking around. It's not an unreasonable conclusion that the knife was in motion in the car. It's consistent with the other testimony. Now, Mr. Stephan and I definitely disagree on this fact. And it's the motion, whether or not the stab wound was consistent with the motion that Mr. Acre-Kendall described. We know that the stab wound went from front to back, from left to right, and at an upward angle. But as Mr. Stephan describes it, he's doing this. He's taking his arm in a downward stabbing motion, but that's not the gesture that Mr. Acre-Kendall showed you yesterday. That's what he did. Upwards, left to right, front to back. The medical evidence is consistent, in our opinion, with the exact testimony of Mr. Acre-Kendall. Think about the shoe print, right? Mr. Stephan says that none of this science really tells us anything, but I beg to differ. The shoe print. We know that there was a muddy shoe print on the frame of the door. And we know that it was not Mr. Kelly's shoe. But what did Mr. Acre-Kendall tell you? Where was his foot as he attempted to hold himself back in the car, in that very spot? The science is consistent with what Mr. Acre-Kendall told him. think about the undisputed facts. Analyze the consistent evidence. The second guideline I propose is that you do not be misled in your deliberations by the minor inconsistencies. It's kind of like what Investigator Gerhardt and Investigator Vitalis said, that when they're at a crime scene, they put markers on anything that could possibly have any relevance to this case. And in the end, the vast majority is completely irrelevant. Was it five? Did Mr. Kelly say that I'd be over in 5 minutes, 10 minutes, or 15 minutes? Because there were some inconsistencies about that. But it's a distraction. Because ultimately, everybody agrees that Mr. Kelly or Mr. Leckman said, we'll be over in some specified amount of time. So don't be distracted by minor inconsistencies. There was minor inconsistencies. Well, they showed up 45 minutes later, an hour later, 90 minutes later. It's an inconsistency amongst the testimony. But ultimately it doesn't matter because Mr. Leckman and Mr. Kelly showed up. The distances that people describe. Mr. Kelly says that they parked maybe 40 yards away, 50 yards away from that tree. That was his perception. But we know that, according to Sergeant Dale Hall, the distance between the two cars was 200 yards. But neither of those facts changes the other. Those inconsistencies are irrelevant. The fact that Mr. Leckman perceived it to be 45 yards, 50 yards, and in fact, it's 200, it's a minor inconsistency. What were the exact words exchanged when Mr. Leckman and Mr. Kelly came out of the woods? Jacob Mossberg said in his statement, it was, "We're right here, man." But he testified here in court that they said, "We're right here, you pussies." And Mr. Steffen grilled him about that. Inconsistency. That one word, it's a minor detail because everybody agrees that in some derivation or in some fashion, Mr. Kelly said, "We're right here." Think about the inconsistencies about Hank Michaels. Did he go around the front of the car or the back of the car? It doesn't matter. Ultimately, it doesn't matter because everybody agrees that at some point Mr. Michaels attempted to be the peacemaker, that he got in between the two in some fashion and said, "Hey, enough guys, we don't need this." Did Mr. Kelly call him a lanky bastard, a lanky motherfucker, a lanky son of a bitch? It doesn't matter. All three remember the adjective, but not the expletive. It's a minor inconsistency. After Mr. Kelly was stabbed, did he say, "He knifed me, he poked me, he stabbed me"? Doesn't matter. It's a minor inconsistency. And these inconsistencies illustrate the problem that we have with eyewitness testimony. Two people can witness the identical incident. They can be standing right next to each other, see the exact same thing, and have two complete versions of it. The light was green, the light was red. He said this, she said that. We exist here right now in the vacuum of a courtroom. And in this courtroom, for some strange reason, we, the lawyers, expect perfection from every witness. We expect witnesses to remember things that they said 8 months ago. We expect witnesses to have a clear, consistent, precise story. And if they don't, we call them on it. And that's not reality. The reality of the situation is Mr. Leckman just lost his best friend. He held his best friend as he lay dying. It was traumatic for him. Mr. Acre-Kendall just stabbed Mr. Kelly. It was traumatic for him. All of his friends testified to their levels of fear and what they felt. It was traumatic for them. But yet we expect precision out of trauma. The statements of these witnesses do not need to be consistent to be reliable. And you can just apply this in a common sense kind of a scenario, because the law says, again, that you get to apply your own common sense. And haven't you ever been in a party and you and your spouse or your significant other or your college roommate are recalling something, some story, some event from your life, and you say, well, this happened. No, that happened. No, that. And you get into this argument about what happened first and who said what. Because that's the reality. These minor inconsistencies ultimately tend to detract from the ultimate mission of this jury, which is the truth. Third, attempt to reconcile the important inconsistencies. In the jury instructions, page 11, it says, if you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. Reconcile the inconsistencies. Ask yourself, what makes the most sense? What's the most common, reasonable, logical deduction that we can make? But here's the advantage that you, as jurors, have today that Mr. Leckman and Mr. Kelly and Mr. Acre-Kendall and his friends didn't have on April 14th. You have both sides of the story. So think about this exchange across the river, right? Who started it? Mr. Leckman testified that Mr. Acre-Kendall and his friends started the altercation. But Mr. Acre-Kendall says, no, they started it. But when you take these two stories and you analyze their evidence, can they be merged into a consistent story? They can. Because our facts, as we believe them, are dependent upon our perspective. Mr. Leckman says that this all started by these young men calling them homos and fags. And we've all learned that that's not an uncommon way for any of these individuals to talk. And we heard the story about watching these videos and saying things like, do you want some of these nuts? And the response of the friends amongst each other. It's not unreasonable for Mr. Kelly and Mr. Leckman to believe in their minds that those words are directed across the river. Likewise, from Mr. Acre-Kendall's perspective and that perspective of his friends, they're goofing off. They're having a blast. They're having a good time. And all of a sudden, they're told to shut up. And they're confused. And we didn't even do anything to you guys. So from their perspective, they started it. You can take those two stories and you can reconcile them. They're not that inconsistent. And ultimately, not that important. Think about the question of whether Mr. Acre-Kendall was seated in the car with both legs, one leg out, half sitting, his butt almost touching the ground or touching the seat. Think about the perspective of each of the witnesses. Can they be melded together? Can they become consistent? Because again, this is not a situation that took 5 days to unfold, or took 100 pieces of evidence to explain, or 17 witnesses. This incident happened in a matter of moments, minutes. Mr. Michaels, he says that he's sitting down, in the process of sitting down as Mr. Acre-Kendall gets pulled from the car. Mr. Mossberg says he's in the back looking through. Mr. Phillips says he's in the back seat when it happens. Mr. Leckman says he wasn't even looking at that particular moment. He was looking away for 3 or 4 seconds. But from each of their perspectives and each of their recollections, their recollection is the correct one. What we know is, again, there's no disagreement, at least amongst Mr. Acre-Kendall and his friends, that he was violently ripped from the car. That's the way it was described. You can reconcile those inconsistencies by applying the perspective. Use your common sense. Use your personal life experiences. That's what the rule of law says you can do. The fourth consideration you should apply to your deliberations. Actions speak louder than words. Mr. Leckman told you, and he told investigators, that it was not his intent or Mr. Kelly's intent to start a fight. They just wanted to teach these guys or talk to these guys and express their feelings about the park and their behavior. He had no ill intent. Yet they parked in one of the farthest stalls away. They walked quietly through the night. They didn't bring their flashlights or their phones or their keys. They could have just as easily driven right up to that car and said, "Hey guys, you guys got to calm it down a little bit." And then they would have been in the safety of their car. So if there's 15 people, they could have just driven off. They stopped and assessed the situation. Were there 3? They wanted to make sure how many people were there. There wasn't like 15 people. Because remember, there were like 15 people on the riverbank earlier that day. But when they concluded that it was only 3, then it was okay to approach. So that implies that somewhere between 3 and 15, there's a breaking point. We can take 3 guys, but we can't take 15. What's the number that would have made them turn around between 3 and 15? They immediately threw him to the ground. Again, going back to that idea of the details and the minor inconsistencies, does it really matter if it was Mr. Kelly or Mr. Leckman who threw Mr. Acre-Kendall to the ground? No, because again, everybody agrees that it happened, including Mr. Leckman. And what is their response? What kind of pussy pulls a knife? They menace Mr. Acre-Kendall. They target him specifically because they recognize his voice. Mr. Phillips, Mr. Mossberg, Mr. Michaels, they didn't have the same fear or perspective that Mr. Acre-Kendall had. Mr. Acre-Kendall is being apparently a smartass. The knife does not de-escalate the situation. It escalates it. What kind of pussy pulls out a knife? Put the knife down and let's duke it out like a man. That's what Mr. Leckman said, Mr. Kelly said. Put down the knife and let's duke it out like a man. As Mr. Acre-Kendall is walking along the side of the car, he's not swinging his knife. He's not jabbing or trying to poke Mr. Kelly. He's backing up. He's walking sideways. It's Mr. Kelly who's lunging at him and trying to get him to get rid of the knife, to scare him. Scare him so bad that he backed into the car, and at this point, Mr. Acre-Kendall has nowhere to go. The car is behind him. Mr. Leckman is to his right. Mr. Kelly is in front of him. His only way to go is in that car. Let's put down the knife and duke it out like men. You guys can go. Go ahead. Get out of here. Get out of here. But does he let him get out of there? No, he lunges into the car and violently rips Mr. Acre-Kendall from the car. Mr. Leckman and Mr. Kelly's actions spoke louder than words. A lot has been said about Mr. Acre-Kendall being a smartass, right? He's mocking him. Oh, yeah, I'm a pussy. You're a pussy. Yeah, I'm a pussy. You're a city kid. Yeah, I'm a city kid. You're a big tough guy with your knife. Yeah, I'm a big tough guy with my knife. Right? That doesn't slow Mr. Kelly down. It makes him matter. Consider Mr. Acre-Kendall's words and his actions. He's backing up. He's slowly going towards the door, trying to get the door open. What do his actions say? His actions say, I want to leave. Not only do they say, I want to leave, I am leaving. I am retreating from this situation. I don't want to fight. I don't want to fight. This is not a fight. Actions speak louder than words. I would venture a guess that the vast majority of this trial has been focused on the so-called consciousness of guilt evidence. That you can infer from Mr. Acre-Kendall's actions after the incident that he intended to kill Mr. Kelly. Were there bad decisions? Oh, there were bad decisions. There were lots and lots and lots of bad decisions that day. Starting when Mr. Kelly and Mr. Leckman decided to take the law into their own hands. But when you consider this consciousness of guilt evidence, and you really think about that statement, are actions louder than words? Let's think about that. Did Mr. Phillips admit to you that he disposed of the marijuana? Yeah, he did. He threw one bag out into the woods, and the other bag he just dropped out of the car window. Within 0.3 of a mile before they even got out of the river bottom. If you're thinking that you're going to dispose of evidence in such a way that the police wouldn't find it, would you leave it 0.3 of a mile from where Mr. Kelly died? This is not a master criminal plot. This is panic. And when you're scared and you're panicking, you make stupid decisions. But everyone agrees that Mr. Acre-Kendall did not throw out the knife. Actions speak louder than words. You've seen the knife. The knife has been opened in this courtroom repeatedly. If you're going to get rid of evidence of a crime, aren't you going to dispose of the single most important piece of evidence? Or a nickel bag of marijuana? He calls his dad. He's 19 years old. All of these young men live with their parents. Mr. Phillips is still in high school. They call his dad and wake him up. And Mr. Kendall told you, I was sleeping, taken by surprise, took me a few minutes to kind of process it. And his dad did what any dad would do. I propose. Come home. Let's figure this out. And the unfortunate reality is that life sometimes gets in the way of important things. And you don't realize the significance. Were there bad decisions? Absolutely. What does Mr. Kendall tell his son? Well, you're going to go to jail. If you stab someone, you're going to go to jail. His dad didn't know the whole story. Come home and let's figure this out. Mr. Steffen proposes to you that it defies logic that they weren't talking about it in the car. But really? It's okay, and I agree with Mr. Steffen, that it's okay for Mr. Leckman to not give us all of the detail in that first statement. I agree that there's a reason why you usually wait 24 hours or 48 hours to take a statement after a critical incident. Your body is coursing with adrenaline. You're fearful. You're terrified. But actions speak louder than words. And he goes home. The next day, when they learn about Mr. Kelly's death, Mr. Michaels walks off his job. Just walks off. Doesn't even tell his boss. Because he knows he's got to deal with this. Unfortunately, I wish I could change the facts, but unfortunately, Mr. Acre-Kendall didn't have that same opportunity. He was 45 minutes away from where he was in someone else's car. He didn't have that same opportunity. Those three young men, Mr. Phillips, Mr. Mossberg, and Mr. Michaels, they didn't know of this miraculous, coincidental discovery of the receipt. They didn't know that law enforcement was already in their hometown. They went to a lawyer and they called the authorities. Actions speak louder than words. Those three young men answered every question asked of them. Twice, on April 16th and on May 12th. They didn't have to. There's no evidence of a grand conspiracy of silence. They give the police their cell phones. They don't delete anything from them. Mr. Michaels sent an insensitive, disrespectful, vile text message. That's why I don't bring you fishing, LOL. And you, as the judges of credibility, saw his demeanor. He was not proud of that. But he didn't delete it. He didn't hide it from the police. He gave his phone to the police and disabled all of the password protections to make it easier for the police to find that evidence. Levi's at work. Mr. Acre-Kendall is at work. And he goes home knowing that the police are there for him. He doesn't run. He doesn't hide from the police. He goes home. And he's upset. And what does he do? Remember, he didn't toss the single most important piece of evidence. He gives it to the police. Here you go. Here's the clothes I was wearing. Here's my cell phone. Look, I want to talk, but all of these other people are telling me I shouldn't. He turns himself in. He saves the state the expense of extraditing him. And during this trial, he gave up one of his most fundamental constitutional rights, and he told you what happened. He answered every question of Mr. Stephan, and he admitted to things that he could have easily lied about. I smoke marijuana all the time. He told you what happened. This meeting, this big conspiratorial meeting that took place where they're discussing whether he should dump the knife or not, Mr. Acre-Kendall could have sat here and told you, yeah, that happened. I took the high road. I knew that I was going to have to turn in this knife. But he didn't do that. He honestly told you that he didn't remember any of that. He gave him the knife. He remembers Mr. Michael saying, did you get the knife out of my car? And he's, yeah, I got it right here. And he brings it home. He felt like he was outside of his body. Yeah, he knew that he had just stabbed someone. But actions speak louder than words. Finally, and this is the most important job you have, is you have to apply the facts to the law. The law. Here's what the law does not say. The law does not say that you have to be punched, kicked, choked, anything to use self-defense. There is no law that says you can't use self-defense until you're punched, choked, kicked. What Mr. Stephan is essentially urging you to adopt is essentially the same thing that Mr. Kelly said to Mr. Acre-Kendall that night. Put down the knife and duke it out like men. He said, in the state's opinion, this was an invitation. Come on over. Duke it out like men. He makes a big point of saying he'd not been struck, he'd not been choked, he had not been kicked. But the law doesn't require that to happen before you get to use self-defense. The law also doesn't say, nowhere in those instructions, that if you're a jackass or you're a smartass, that is a reason to be assaulted. Sticks and stones, people. Sticks and stones. Read the law. And there are two ways that you can read this law. And in both ways, you find Mr. Acre-Kendall not guilty. First is without even considering self-defense. Without ever even thinking about, was this a justified act of self-defense? In terms of the second-degree intentional homicide, the state has to prove beyond a reasonable doubt that Levi Acre-Kendall acted with the intent to kill Peter Kelly. And that's what Mr. Stephan just told you. But the law, the words of the law, the rule of law says that intent to kill means that Levi Acre-Kendall had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. That's what intent to kill means. Can intent be formed in a matter of seconds? Matter of an instant? Absolutely. But so can the fear that justifies self-defense. We'll talk about that. And as you apply the facts in this particular case, can you honestly believe that the state has proven beyond a reasonable doubt that Mr. Acre-Kendall intended to kill Peter Kelly? Or that he was practically certain that his action would cause that result? He told you, I swung the knife. I intended to stab Mr. Kelly. He didn't know where. He didn't conduct an anatomical examination of Mr. Kelly to find the specific spot between the 5th and the 6th rib. Is a stabbing practically certain to kill someone? Certainly is one possibility. People get stabbed every day, and they're fine. The second charge, the first-degree reckless homicide. Again, Mr. Stephan says reckless conduct and utter disregard for the life of another. But again, the law has a lot more to say about that. What is this reckless conduct? It's not just reckless behavior. It's not just being stupid. It's criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and that Mr. Acre-Kendall was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Read the law, the rule of law. These words have tremendous meaning. The state can't prove criminally reckless conduct. Likewise, in the first-degree reckless homicide, Mr. Stephan tells you about the utter disregard for human life. law goes on to say that in determining whether the circumstances of the conduct showed an utter disregard for human life, consider these factors. What was Levi Acre-Kendall doing? Why was he engaged in that conduct? How dangerous was the conduct? How obvious the danger was? Whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. What was Mr. Acre-Kendall doing? He was trying to leave. He was pulled out of a car. Why was he engaged in that conduct? Because he had just been thrown to the ground and was being menaced by two, and I will say yes, bigger men. Mr. Acre-Kendall wasn't swinging. No. He didn't stab Mr. Kelly as he entered the car. He was trying to stay in the car, keeping the knife away. He didn't stab him at that point. He didn't stab him when he got pulled out of the car. He didn't want to do this. These words have meaning. And I don't care. But the state has not proven beyond a reasonable doubt criminally reckless conduct and this utter disregard for human life. The third charge, the second-degree reckless homicide, only requires the state to prove that criminally reckless behavior that we just discussed. So you can go through each of these three charges, and on the facts of this case and the law that applies, the state has not proven beyond a reasonable doubt an element of that crime. And the state has to prove beyond a reasonable doubt each element. If any one is not satisfied, the verdict must be not guilty. But this is self-defense. This act was an act of self-defense. And so again, what does the law say about self-defense? It says that Levi Acre-Kendall is not guilty of any homicide offense. Any homicide offense. If Levi Acre-Kendall reasonably believed that he was preventing or terminating an unlawful interference with his person, and that he reasonably believed that that force was necessary to prevent imminent death or great bodily harm. That's what the law says. But it also says more. The state has to prove beyond a reasonable doubt that Mr. Acre-Kendall did not act in self-defense. That he did not act in self-defense. The law says even more. That as you sit here as a jury, you have to put on and put yourself into the perspective of Mr. Acre-Kendall. This determination about the reasonableness of his actions is not from your viewpoint, sitting here in the vacuum of the courtroom. The reasonableness of Mr. Acre-Kendall's belief must be determined from the standpoint of Levi Acre-Kendall at the time of his acts, not from your perspective here. So let's talk about Mr. Acre-Kendall's perspective. He's 45 minutes away from home. He's in a familiarly unfamiliar place. He knows the park. This is where he fished. It's where they fish a lot. And he could probably, or he could, drive you to the park. He's 45 minutes away from home. He doesn't know the area. He couldn't tell you the name of the highways or where things are necessarily located other than maybe the bait shop that they stop at. He's in the pitch black. Pitch black. Surprised by two larger men who told him that they were coming over. And I would agree with Mr. Stephan on one point, as an aside, that the verbal jaw-jacking, that wasn't a tremendous concern of Mr. Acre-Kendall. It's easy not to be overly concerned when there's 200 yards across the river. But he knew he probably pissed him off. Two larger men. Mr. Stephan says, Mr. Kelly's only 2 inches taller. But again, look at the evidence. And the evidence that's been submitted in this case consists of Mr. Kelly's autopsy. Mr. Kelly is 5'8", 192 pounds, well-developed and well-nourished. He's only 2 inches taller. He's 40 or 50 pounds heavier. He's bigger. He's 34. Mr. Acre-Kendall is 19, 5'6", 140 pounds. Mr. Leckman tells you that at that time, he was 220 pounds. And you saw the recreation. You saw how big and full Mr. Leckman is. Mr. Phillips said, I couldn't believe how easily he took. Yeah, Mr. Acre-Kendall, he's the guy that usually doesn't take shit, but I could not believe how easy he got tossed. They were bigger. It was dark. And he knew that in all likelihood it was the same two guys from earlier. He's immediately thrown to the ground. And so quickly that he couldn't even tell you who it was. And he gets up and he pulls a knife. And the knife doesn't stop this guy. The knife does not de-escalate the situation. It makes it worse. How terrifying is that? That you're holding a knife and saying, I don't want to fight. Want to feel a real man's muscles? You want to feel a real me? It doesn't stop him. Yeah, in the vacuum of the courtroom, it's easy to say what if. Well, you got a shotgun in your car and plenty of ammo, and well, Mossberg's just that guy, right? All three of these guys say, yeah, we would have jumped in, we would have helped him out. But did they? At that time, did they? Mr. Phillips, Stevie Phillips, was terrified. He was so scared. 17 years old, a senior in high school. He's scared. Mr. Michaels was scared too. He had never even been in a fight. They didn't come to his aid and come and stand by him or try to get him out of the situation. Only Mr. Michaels did. Only Mr. Michaels tried. And what happened when he tried? He was brushed aside. Get out of here, you lanky motherfucker. Lanky bastard. Mr. Acre-Kendall described his sense of doom. He's not swinging the knife. He's backing away. He's retreating. He's pushed ultimately into the car. And he's saying, I don't want to fight. He has nowhere to go. The door is now open. He can't even go that way. Mr. Kelly is within arm's reach. And Mr. Leckman is right there, and the car is behind him. Where can he go? This is not a bar fight. This is not a bar fight between two guys who decide to drop the gloves. I just wanted to leave, is what he told you. He is telling these guys, I want to leave. Is he being a smartass about it? He's scared. Come and feel the real me. Come and feel my muscles. Drop your knife. Duke it out like a man. And when he finally is able to get in or almost on the seat of his car, he's pulled out. He's pulled out. And he described for you what he saw. And what he saw, what he tried to do first was to stay in the car. He's fighting to stay in the car. He's got his foot and he's trying to get leverage to stay in the car. He's not stabbing Mr. Kelly at this point. He's trying to stay in the car in his safety spot. It's the only way he could terminate. It's the only way he could terminate. He didn't stab Mr. Kelly 10 times or even twice. So the question is really, at that moment, and in that moment, did Mr. Acre-Kendall reasonably fear great bodily harm or death? And the state says that this is preposterous. Again, the state is saying, basically, sometimes you just got to take your licks. Drop the knife and duke it out like a man. Again, the law has something to say about what great bodily harm or death, imminent fear of death or great bodily harm is. Recently, there have been a rash of one-punch incidents. Philip Nelson and Trevor Shelley were football players down in Mankato. Philip Nelson actually played for the Minnesota Gophers. Trevor Shelley, they were friends. And with one punch, they punched Isaac Kolstad, and he dropped to the ground, and he hit his head, and he spent the next several months in rehab. One punch. He didn't die. It's not a temporary injury. That was a permanent injury. So I asked Mr. Kolstad about a fear of great bodily harm or death. In Buffalo, Minnesota, Alexander Tomisto learned that lesson as well, when with one single punch, he killed Adam Baker. Martin Walker of Racine, Wisconsin, learned that lesson too, when with one single punch, he killed Colin Byers. David Clifford of the Minneapolis Police Department was off duty at a bar. Some guys were being obnoxious next to him, and with a single punch, Brian Vanderlee will never be the same. According to the Sydney Morning Herald in Australia, between 2000 and 2013, there were 90 one-punch deaths that prompted the lawmakers to change the law, to make it a serious crime. When Mr. Acre-Kendall is in that moment, when you put yourself in his shoes, he's not thinking, A, B, C, is this a broken tooth? Am I going to get a black eye? Am I going to maybe break my nose? He's scared as hell. And the suggestion, you just duke it out like men, is contrary to the rule of law. Your job here as jurors is the truth. It's the search for the truth. It's not solving a puzzle. It's the truth. And for that reason, I ask you to find Mr. Acre-Kendall not guilty of all counts. Thank you.
Mr. Steffen.
I'll be brief, I promise. You've heard a lot, and so I'm not going to sit here and rehash everything, but I want to talk about just a couple of things. Because while the defense now indicates that somehow I'm saying you're supposed to duke it out, that's not the case. But before you use force that you reasonably believe to either cause death or great bodily harm, you got to have more than just fear. It's interesting that when Mr. Acre-Kendall, the defendant, was on the stand, he wasn't asking any of those questions about all these one-punch deaths. In fact, he wasn't asked the question, have you ever heard of a one-punch death? Because you've got to look at what he was thinking at that time and then determine if what he was thinking at that time was reasonable. What was he thinking at that time? He was thinking, I had just been in a physical altercation with the bigger guy. And as a result, I scuffed my knee. And what's his response to that? He pops out that knife, and he pushes that button, and knife pops into action. He doesn't show him the knife, doesn't just take it out of his pocket and say, I got a knife. Back up. Back up, I've got a... In fact, he doesn't even leave it in his pocket and say, back up, I got a knife. Doesn't reach in his pocket and pull it out and say, I've got a knife, and show it. No, when he's first pushed to the ground, he forms an intent to use that knife. He pushes that button and pops that blade into action. He was ready at that moment to use that knife to stab someone after he had been pushed down. And this attack, let's be clear, Ross Leckman says he comes at him, and he pushes him away to get him out of his space. So there's plenty of dispute about this first physical contact. I encourage you to read those instructions carefully when it talks about intent, when it talks about reasonableness, when it talks about criminal acts. Read it over carefully, because nowhere is it going to be ever reasonable to look somebody eye to eye. And I've noticed that Mr. Nelson in his closing didn't address either of the defendant's two friends who say that they're arm in arm, shoulder to shoulder, eye to eye. Never discussed how those two individuals got it so wrong that according to him he was bent over somehow. It does defy logic. He's got to have, when he sticks that knife in the ribs of Peter Kelly, he's got to have a reasonable belief that he's in danger of imminent death. I don't think I need to define what imminent death is to you folks. Or great bodily harm. And you heard the definition, but let me repeat it one more time. Great bodily harm means injury which creates a substantial risk of death, or which causes serious, permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or similar injury. And yes, that means that it has to be something more than pain. It has to be something more than something that requires stitches or the glue. It has to be more than a broken nose even. A chipped tooth. It has to be more than that. It has to be more than a temporary loss of consciousness even. It has to be more than that. In order to use that type of force, which is likely to cause death or that same great bodily harm, and when you stick somebody in the ribs with that knife, that's what's going to happen. I'm not going to belabor a whole lot of other things, but let me just, a couple of giant leaps that were made. There's been no evidence presented that that shoe print in the doorway was the defendant's. None whatsoever. So to make that leap at this point to say that somehow that shoe print in the doorway was the defendant's shoe print pressing back with leverage, and no evidence presented of that at this point. The only evidence that was presented was that shoe did not belong to Mr. Kelly. That's all we know. You know, and we can argue all week about who was saying what and what to whom. It was uncommon for two of these individuals to be talking about gays, homos, and fags. You heard that from Ross Leckman. That was uncommon. You heard from four of them that it's almost a daily occurrence with the defendant and his three friends. He also makes a very big deal about not throwing out that knife. That $260 Alishewicz striker knife, and that knife that Jake Mossberg says was used to puncture things. And I assert to you, yeah, he didn't throw it out because it was his knife. He carries around with him all the time. It's his cool guy knife. It's not because he had some kind of interest in helping law enforcement. My goodness, folks, he did not turn himself in. He was caught. He was told to come home from work because the cops were at his house. Was he allowed to report to the sheriff's department the next day? Yeah. To prevent a difficult extradition process from Minnesota to Wisconsin. They could have arrested him on the spot and extradited him. They chose not to do that. Did he turn himself in? Absolutely not. It's ridiculous. and that somehow, I agree that those 3 guys that testified, his friends, came up and were interviewed, but let's not sugarcoat it. Of course you're going to want to be, at that point, treated as witnesses, not suspects. They also know that they committed potentially some crimes themselves. They want to cooperate. They've got reasons to cooperate other than this just intimated just concern about helping out. They certainly had some motives to at least tell the story. Now, this case, it's interesting that I usually come up and say, I get the last word. And in this case, it's interesting because I think some of that is what this case is about. This defendant had to get the last word. Every time somebody said something to him, he had to say something back. If in fact this, I'm going to come over and put you to sleep, I ain't even tired. We'll be over in 5-10 minutes. I see you then. He felt the need to constantly get in the last word. He even acknowledged that on the stand. Every time something was said to him, he said it back. Does this sound like somebody who's so scared and frightened? No. He's got the knife. I am a big man with my knife. We've heard all the statements about how, I just want to leave. I just want to leave. Let me read some of his own statements. And while actions do speak louder than words, actions plus words equal intent and show a lot of things. You pussies didn't even show up. And even Stephen acknowledged, hey, you got in the last word. He gets pushed down, pops up with the knife. What the fuck? By his own testimony is what he says. We want to make a big deal of this. Come out and see my muscles, if that was ever said. His testimony was that was in response to, I'm a big man with my knife. And then when he supposedly sits down, he even testified that when I sit down, he says to Mr. Kelly, oh, you're a big badass. Oh, he's so scared. He's so scared. He sits down in that car. Yeah, you're a big badass. You're a real badass. And then something else is said, and what does he do? Shrugs his shoulders. He's got to get in the last word. And then he testifies that even after he sits down, and he's so scared for my life, I'm in fear of imminent death or great bodily harm, he sits down with the knife. We done? We done yet? Another invitation. Another invitation. He's always got to have the last word. He even has to have the last word the next morning when he plays that video for his buddies on Facebook. Got the last word. D's nuts. Thumbs up from Jacob Mossberg. Ultimately, this defendant got the last word. Stuck that knife right into the ribs. Peter Kelly, he got the last word. Now as I sit here today, as I sit here right now, I don't get the last word. Mr. Nelson doesn't get the last word. Even Judge Gilwire doesn't get the last word today. And for as long as you deliberate, you folks get the last word. You can go deliberate and you come back and you get the last word. Find him guilty. Find him guilty beyond a reasonable doubt. Absolutely, this was no self-defense in any kind of reasonable manner. Beyond a reasonable doubt. Search for the truth. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. I've instructed you regarding the rules of law which should govern your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind, and as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. If you want to pick up your verdicts, they're stapled together. The following 6 forms of verdict will be submitted to you for your consideration concerning the charges against the defendant, Levi Acre-Kendall. The first reading, we, the jury, find the defendant, Levi Acre-Kendall, not guilty of second-degree intentional homicide as indicated in the information as count 1. And not guilty is always the first option given to jurors because of the presumption of innocence. If that's your verdict, it would be dated whatever day it is when you decide this, and the jury foreperson would sign. The second reading, we, the jury, find the defendant Levi Acre-Kendall guilty of second-degree intentional homicide as indicated in the information as count 1. The third reading, we, the jury, find the defendant Levi Acre-Kendall not guilty of first-degree reckless homicide as indicated in the information as count 2. The fourth, we, the jury, find the defendant Levi Acre-Kendall guilty of first-degree reckless homicide as indicated in the information as count 2. The fifth, we, the jury, find the defendant Levi Acre-Kendall not guilty of second-degree reckless homicide as indicated in the information as count 3. And finally, we, the jury, find the defendant Levi Acre-Kendall guilty of second-degree reckless homicide as indicated in the information in count 2. It is for you to determine which one of the forms of verdict submitted to you you will bring back as your verdict. Ladies and gentlemen, this is a criminal, not a civil case, and therefore before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by written note. If you have questions, I will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you've reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom, and I should tell you the time frame. The courthouse is going to be emptied and it's going to be closed during your deliberations. So once you have notified the bailiff that you have a verdict, I will notify counsel. They will notify whomever they're assigned to notify. Law enforcement will be contacted, and 1 hour after you have notified me that there is a verdict, and of course I don't know what it is in this hour, then we will come into open court and read it, and that's to allow everyone to reassemble to hear the verdict. The verdict then will be read into the record in open court, and I will poll the jury is what the legal term is, which means I'll go down the row and ask each one of you if that is your verdict. Madam Clerk, would you please swear the officer?
Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? Yes, I do.
And now, ladies and gentlemen, it's time for me to announce the name of the two alternates. The alternates do not deliberate. Normally, the way that alternates are chosen in this county is that we would randomize the 14 names in the computer, and the last two names would then be the alternates. In this case, because we picked a jury from another county, our computer system isn't able to do that. So we went the old-fashioned way, and we put your names in a hat, and the names were pulled out. Before I announce the names, I want you to know that we do have transport available to return you to Chippewa County, if that is your wish. If, on the other hand, you wish to stay until the verdict is reached, you could certainly do that. You obviously would have to be transported back to the hotel because the courtroom is going to be closed, but you would then be notified when the verdict is ready and could be transported back, and you could have a seat in the courtroom. It's totally up to you. The two alternates are Wendy Schmidley and Eileen Sikora. So I'm going to ask, you may have some of your things in the jury room, so once I release you, please get your things and come out into the hallway, and you can let me know what your wish is, whether to stay or be transported back to Chippewa. I want to thank you both for your service. You have sat through 6 days now of very difficult evidence, and you have, like all of the jurors, comported yourself in a very respectful and attentive fashion. Nobody could have asked for anything more. I want you to know that everyone who's dealt with you, whether it's the bailiff, the transport officer, they all have nothing but